The public protector's finding on the Sars intelligence unit is irrational and likely to be set aside. Well, that's the view of constitutional law expert Pierre de Vos. Mkhwebane's report says Pravin Gordhan breached Section 209 of the Constitution by establishing the unit when he was Sars commissioner. But de Vos is not convinced. He says it can be argued that Gordhan approved the establishment of a covert information gathering unit and not an intelligence service. To explain his views, he joins us now from our Cape Town office. Good evening, Prof. Thank you very much for your time. Tell us why you think that the Public Protector's report won't pass the rationality test.
Well, I made the argument that some parts of it will not pass the rationality test, and the part about the establishment of the Sars investigative unit, that is unlawful. I think that is clearly wrong. The Nugent Commission agrees with this position, as well as some senior counsel lawyers who gave advice to Sars, and the reason for this is very simple. The relevant legislation says that only intelligence services can investigate covertly departmental intelligence. And nobody else can, except if the president gives permission, of course. But then they defined what is an intelligence service, what is the kind of intelligence that they're talking about, and they're talking about investigations about state security, about protecting the constitutional democratic system. So if you investigate something else, even in a covert manner, but it doesn't relate to state security, it doesn't relate to protecting the constitutional order, then it's not an intelligence service. Then you investigate somebody else. It's like the Home Affairs investigating, for example, whether two people who got married as a matter of a sham, in a sham marriage. If they investigate that, they don't become intelligence service. They're still the Department of Home Affairs doing its job, which might include investigating certain matters.
So that's the basis on which you reckon her report is based on misrepresentation of the law, or at least parts of it.
Yes, the strange thing for me about that part of the report is that the Nugent Commission clearly referred to the relevant, or by implication at least, to the relevant definitions in the legislation that makes this very clear, but the report does not engage with that. It does not make any argument about why Sars investigating tax matters, why that makes them an intelligence service. There's no argument there. There's no engagement with the counter-argument which the Nugent Commission and the various lawyers found, which is not really comprehensible because it doesn't make sense. If you're going to make an argument, you're going to engage with the counter-argument. This didn't happen in the report.
Well, the other thing, of course, you raise about the Public Protector's report is that, and I quote, it cleverly attempts to speed up Gordhan's political demise by requiring remedial action to be taken against him within 30 days. Is there something wrong with that in law?
Well, what the Public Protector has done in the report, and that's why I say it's clever, there's a debate going on between lawyers about what happens if you make a report and you hand it down, and then somebody goes to the court and has asked that report to be reviewed and set aside. What happens in the meantime? Should the remedial action be implemented despite the fact that there's a court case or not? What the Public Protector said is, well, my findings and rulings are binding. I say that the way I understand the Constitutional Court is that these are binding unless you get a court order to set it aside. So I'm basically ordering you to implement this even if you do go to the court and you ask for a review even before the review is heard. So that is a clever thing to do. We will see what the courts say about it. What this actually then means, I think, is those who don't want to have the remedial action implemented will have to go to court and ask for an interdict to stay the implementation of the report until such time as there is actually a review of the actual report.
Why is the law not so specific on this matter? One would imagine that there has to be a reason why the law is not as watertight as perhaps it ought to be. What could be the reason?
Well, there's two reasons. Firstly, the public protector is not a court of law. It doesn't work in terms of the procedural rules that are applicable to criminal cases or civil cases, where that is all sorted out. So we are really relying on the Constitutional Court judgment, most famously the Nkandla judgment, and there the Constitutional Court made statements that could be interpreted either in favor of the public protector's position, and then they made other statements that could be interpreted in favor of the Pravin Gordhan and President Ramaphosa's position. So we haven't yet really sorted that out, and I think that's really why we don't really have specific applicable procedural law that applies to the public protector, and so we're not really sure how it will pan out and what the actual position is.
Okay, Prof, that's where we're going to leave it. Thank you very much for your time, Professor Pierre de Vos, live from our Cape Town studios.